Hi guys, Lisa Figueroa here, board certified criminal defense attorney in Orlando. So I recently put out a video asking you all for some suggestions on topics or questions that you might have, and I got one from one of our subscribers, which were really great, just a whole bunch of good questions. So let me answer a few.
So yes, can you explain grand jury proceedings?
Grand jury proceedings is the process for which charges get filed, typically in federal court and on a few occasions in state court. And what that means is a group in the public, kind of like you would see a regular jury, they gather and it's a secret meeting. The defense attorney doesn't get to be present, and the prosecution puts on the case to basically determine whether or not probable cause exists to indict or charge a defendant.
Can you explain the process for evidence, as in how is it decided which evidence gets presented at trial?
Evidence in cases can come from a lot of things. Sometimes it's just testimony, witness statements, digital evidence, forensic DNA, ballistics, all of that. So how a prosecution or the court determines what comes in is based on what is relevant and also what is supported, what can be laid the foundation as far as, is it valid, is it authenticated? Ultimately, it's kind of a strategy decision. The prosecutor may have a bunch of evidence and they only select a few pieces to show, and the defense is supposed to get all the evidence as well, and they also can identify what is going to be helpful for their case and try to object to anything that might not be helpful or not relevant or not allowed under the rules.
Why do defense lawyers file so many motions before a trial? And what is a motion exactly?
Motions are documents, pleadings. It's basically asking the court for something. So motions are typically filed in advance, so then that way the parties, everyone who's involved, gets to know what's actually going to go to trial. So you may have a motion to suppress to throw out evidence if the police handled the arrest or the stop or the search improperly, and so a defense attorney will file a motion to have that evidence thrown out because the procedures weren't followed properly. And so before trial, you want to know whether or not that gets used. I had a case recently where someone was charged with possession of a weapon by a convicted felon, and we did a motion to suppress in advance, and the judge actually ruled that the police officer did not have a valid basis to search the defendant and threw out the evidence. And so now there's no trial to be had because the evidence that he was being charged with is now thrown out.
What role does a defendant play in the defense developing a strategy?
Great question about who decides what the strategy is and how much can a defendant influence what the strategy in the case is. The defendant, I'm always going to want to talk to my client about what the case strategy is, and it's their case, it's their life, and it's very important that they are very involved in the process. Now, the law says that the lawyer actually has the final say as to the case strategy, but I think it's really important to collaborate with your client and make sure everyone's on the same page with the strategy in the case.
What does objection, sustained, overruled, and sidebar mean?
Another great question. I used to watch TV before I became a lawyer, and I'd wonder, what does it mean sustained? What's the difference? So when defense attorney or any attorney makes an objection, it's saying that something that is being said or attempted to be introduced is improper. But then the judge decides, is it improper or not? And if the judge sustains, that means they agree. If they overrule, they say, no, that evidence can come in. So sustained means you're right on your objection, but overruled means, nope, it's coming in. Now, sidebar is when you see the attorneys approach and go up to where the judge is, that's called the bench. Sometimes the attorney will ask, may I approach the bench? Or if an objection is raised, they don't want you to do what's called speaking objection. So you're not going to be arguing about the merits of the objection in front of the jury. And so sometimes you have a sidebar. Can we approach? And you go up to the judge. So then that way the attorneys can give the arguments about why they believe their objection should be overruled or stand, or why this evidence should come in or not.
And why do defendants have the option to take the stand, and why do they choose to not take the stand in some cases?
Because our Constitution says that we have the right to remain silent. Every defendant has the option to not take the stand. They're never going to be required or forced to take the stand unless it's a violation of probation hearing. There they can call you, and that's different. But on why would a defendant not take the stand, there's a lot of reasons. Not everybody likes to speak in public. People get nervous in front, and your life is on the line. So there's a lot of good reasons why someone would not want to take the stand, and it's not necessarily just because they might be guilty. And sometimes they've already given their statement to the police, or sometimes the state's evidence is just not sufficient. But the law and the rules in the courtroom are set up that no juror should ever hold that against a defendant for not taking the stand. So that's it for now. Great questions. Let me know if you guys are interested in me turning it into a series where we answer more questions like that. If you have any other questions, go ahead and send them in, and we'll keep answering your questions as they come. Take care.